And you're live.
Great. Hi, everyone. Welcome to the AALS 2021 section on Law and Anthropology panel. Today, we are going to operate in a slightly different format. Our panel title is called Representing Qualitative Scholarship. And we have, I think, 5 wonderful panelists with us today, who I will ask to very briefly introduce themselves in a second. But before I do, I just wanted to say a few words about what we're hoping to achieve with this panel and also with the slightly different format that we're going to follow. The goal of this is really to conduct a conversation about the role of qualitative empirical scholarship within legal academia. This is something that, as a legal anthropologist, I think about a lot out of necessity, but also something that has been at the center of conversations I've been having with several relatively junior legal anthropologists, one of whom is on the panel with us today, which means it's also something that I think about out of personal interest. This panel is basically a chance for me to sit back and listen to a lot of very smart people talk about this for my own benefit. Although when I explain the format in just a second, you'll see that my sitting back actually involves a lot of butting in. To the panelists, you should feel free to talk about publication norms and challenges, institutional constraints, promotion and tenure, ethics review, funding requirements, outreach and visibility, whatever strikes your fancy as regards the role and challenges of qualitative empirical research within legal academia. The format that will follow after a quick round of self-introductions is that each speaker will talk for 5 minutes, maybe ending with a question or a provocation, but not necessarily so. And then I'm going to jump in and stop them and open up the floor for conversation among the panelists for about 5 minutes so that the speakers can kind of dialogue with one another and respond to one another immediately. Then we'll move on to the next speaker, who will again talk for about 5 minutes, and we'll repeat the process until the end, when we'll have a chance to collect questions from all of you through the chat function. So feel free to drop your questions in the chat as we're going along, and we'll come back and collect them at the end during the Q&A period. And throw them out to the panelists at the end of the session. The order that we're going to go in is Elise, John, Reshmi, Beth, and Anna. Again, with the caveat that I'll jump in at 5 minutes, so please do try to keep track of your own time, and I apologize in advance for interrupting you if you're at the end of your time. Let me begin by quickly introducing myself. My name is Deepa Das Acevedo. I'm a legal anthropologist on the faculty at the University of Alabama School of Law. I have 2 very distinct branches of research. I do some work with respect to labor and employment law, where I primarily focus on new forms of work like the gig economy. But I also have a longstanding interest in India and comparative constitutional law and law and religion. And I'm at the beginning of a new set of research projects dealing with autocratic legalism and judicial autonomy in India, for which I was supposed to conduct fieldwork in Delhi at several points over the last year, but we all know what happened to that. So with that, let me turn it over to Elise to introduce herself, and then we'll go in the order that we were listed in the program, both for introductions and then back to Elise to start 5 minutes of comments. Go ahead.
Thanks, Deepa. So I'm Elise Berdenthal. I am an assistant professor at Wake Forest Law School. I think, unlike everyone else on this panel, I am not an anthropologist. I have a degree in interdisciplinary field, law and society, and really have, I think, an affiliation and a great admiration for anthropological work. If I could redo my scholarly career. That's the direction I go in, which is why I'm part of this, and also just super fangirl of everybody who's on this panel. So I'm really glad to be here, and thank Deepa for opening up this opportunity.
Great. John?
Yeah, I'm John Conley. I'm on the law faculty at the University of North Carolina in Chapel Hill. I think of myself as a legal and linguistic anthropologist. I, like a lot of you, have two sides to my brain and my life. I do intellectual property law. That's what I think of as my hardcore legal side. And for 100 years, I've researched and written about the linguistics of law. More recently, I've been doing ethnography of science. My current project is an ethnographic project looking at the emerging governance of gene editing.
Rashmi?
I'm Rashmi Dayalchand. I teach at Northeastern Law School in Boston, and I'm a professor there, but also currently the Associate Dean for Research and Interdisciplinary Education. And I'm trying not to feel too much like an imposter, because I have only come to learning about, really, and trying to do qualitative socio-legal scholarship very recently in the course of writing a book on collaborative capitalist practices at the urban sort of municipal level in urban cores. And so I'm certainly looking forward to learning during the course of this panel as well. But I'll also speak a little bit about the relevance of methodology, and in particular qualitative scholarship and methodology in my work as an associate dean for research. And then as far as research areas and teaching areas are concerned, probably my core area is property law. I've always sort of written as a normative property law scholar, but I've also written and teach in the areas of community economic development, local development, as well as consumer law.
Great. Beth?
Hi, yeah, I'm Beth Mertz, and I'm emerita at the University of Wisconsin Law School. I'm pretty much full-time right now at the American Bar Foundation, where I've worked most of my career. I specialize in looking at law schools and the language of law schools from a linguistic anthropological point of view, although I've worked in family law and on family violence as well, and I'm right now doing a long-term study of law professors.
And Anna.
Thank you, Deepa. I'm Anna Offit. I'm an assistant professor at the SMU Dedman School of Law. I'm also an anthropologist and carried out, as part of my dissertation research, a 5-year qualitative study, an ethnographic study in a U.S. Attorney's Office, where I studied federal prosecutors by doing work alongside them. I'm really thrilled to be part of this panel. Thank you again.
Great. So let's move on to the main show. Elise, you've got 5 minutes to give us some thoughts on qualitative empirical scholarship in the Legal Academy.
Thanks. So I thought I'd begin just kind of by situating myself just a little bit to let you know my work is primarily ethnographic. I spent 3 years looking at issues of environmental governance. I'm then transitioning more into an ethnographic project looking at wildlife forensic science. And this is my first year teaching. I'm a pandemic professor. I had a 2-year fellowship, and over this period of transition, I've been thinking a lot about the questions that Deepa has posed for this panel. This idea about translating and emplacing the kind of work that I do in kind of the legal academy. Thinking about is a nice way of putting it. Angsting about is probably more accurate because it feels rocky. And so since this roundtable is meant to generate discussion, I thought I'd focus my comments on a few propositions, or maybe, to borrow Deepa's word, provocations, that I think generally address the potentials or the pitfalls of interdisciplinary qualitative scholarship within the legal academy. So the first proposition I would put forward is that being situated in a law school, a legal space, a legal publication, a legal conference is a really good place in which to produce truly interdisciplinary scholarship. As someone that identifies with anthropology but is not an anthropologist, who has tried in my other persona to think about publishing in the anthropological world, I find that when you're doing interdisciplinary work in disciplinary ways, people expect a foundation that you start from, and then you're reaching out and branching out to have a conversation, and that's very valuable and very important. But when you're not actually situated within a specific discipline, you often find yourself coming into a conversation kind of a little bit clueless, maybe halfway. And so I found being in a legal space really freeing, because I can come into the discipline, this conversation kind of where I want to be, which is, oh, let me tell you about all these theories and methods that I'm drawing together. And I don't have to worry about whether infrastructure is the buzzword of the moment, or I should be talking about neoliberalism anymore. A second proposition, maybe less rosy, is that law is actively engaged in boundary work. I feel much more so than the disciplines that are themselves kind of opening up and reaching out across disciplines. Law has a very strong sense of what looks like law, a legal article, a legal presentation, a legal scholar advancing through the tenure process. And I think that this makes certain qualitative work more or less accepted within the legal academy. I think that there's a hierarchy of qualitative scholarship. Legal historians, I think, have the most success. They have the most ability to talk across these lines. They're admired because they kind of do law in the same way that kind of traditional legal scholars do it, but they do it in very cool, beautifully written ways. I think it's been hard to think about how ethnographic work, which feels exploratory, explanatory, kind of descriptive, fits into this paradigm. And most of my questions start with how. And it's not always clear to me how I go from asking those questions, presenting the results, to the part 5 of the law review article, where you come across and argue what all of this means and why this is so meaningful. I think it advances knowledge, it contributes to theory, but it doesn't necessarily get us to some of those normative questions that people are interested in. I think a third and related proposition is that an exception to this general rule about boundary work is that law really likes quantitative research. And there's this sense that, yes, it's different and it's not what we expect. But there's an acceptance that it's real science, it's broadening what we know in a meaningful way. And I think this quantitative qualitative debate is something that we engage in the social sciences, but I also think it's something that at some level all of us know is a false debate. We recognize that there's different aims and there's different advantages of doing quantitative and qualitative work. There's different questions we're asking and we're looking for. I don't think that recognition has reached the legal academy. And I can't tell you the number of times, particularly when I was on the market, when I had to justify the kinds of research that I was doing. Yes, I understand, you want a hypothesis, but that's not how this research proceeds, or it's not linear in this particular way. So I have a hard time fitting it into the expectations that I think are there. And then the last, and I think hopefully a more hopeful proposition is, try to think about what qualitative research really can be used for in law. And as I was preparing for this panel, I came across an article by a cultural criminologist, Jeff Farrell, who talks about what is the value of cultural explanations of criminology and crime. And he says the value of it is that it provides what he calls an outlaw intellectual critique. And I think that that's a really interesting way of thinking about what kind of qualitative research can be. I think it can serve kind of a similar role for law. Maybe because it is resistant, maybe because it is outside the norm. I think it forces us to look more closely at things that challenge or trouble or otherwise disrupt settled legal doctrine. And so maybe qualitative research is able to provide this outlaw intellectual critique both substantively and stylistically. And there's obviously a lot more to be said, particularly about that last point. But I think the truly meaningful part of the panel is this conversation that we're going to have. And so before Deepa has to jump in and cut me off, I'm going to stop there.
Wonderful. Thank you so much, Elise. That was beautifully done and timely done. I'm going to open it up to the other panelists if you want to respond to anything that Elise has said. Questions, comments, thoughts, please unmute yourself and just go ahead.
Could I just ask about scholarship from clinical faculty, from legal writing faculty? It seems to me that, as often happens, that it's the fringes of the legal academy that is actually producing some of the most interesting work in qualitative methods, and that there's a great deal of of interest there. And I wonder, what your thoughts are about that.
I think that's a great point. I think that's true, and maybe that's that. This is another problem with the boundary work that I see so prevalent in the legal academy, which there's definite boundary work between doctrinal and legal writing and clinical. And my fellowship was actually in the clinic. I'm now a doctrinal professor. I teach criminal law and criminal procedure. And so I do feel like I've been able to read across both worlds. And you're absolutely right. The clinical scholarship, because it feels like you need to understand what's going on outside the courts. And so it makes sense that you want to bring in qualitative interdisciplinary work, and then that it feels meaningful automatically in a way that I think it truly is for even doctrinal scholarship. But it just is more obvious to some extent when you're talking in a kind of clinical milieu.
I found what you said about there being a hierarchy of sort of law and or interdisciplinary legal scholarship within the legal academy really interesting. Growing up as a legal anthropologist at the University of Chicago is a unique experience. And I think it entailed grappling with the question of justifying qualitative research against quantitative empirical research heavily from day one. But I was told something when I was on the market that really resonated with me, which is that setting aside quantitative empirical forms of interdisciplinary legal scholarship, so the law and econ movement, but even, highly quantitative forms of law and political science, or even legal sociology, which has generally tended to be more on the qualitative side, I think, within the legal academy, but it's not entirely by any stretch. That when it comes to more qualitatively oriented forms of interdisciplinary scholarship, anthropology and maybe more heavily qualitative forms of sociology suffer from a kind of presentist disadvantage. That's probably not the best way to put it. But since we're not dealing with history and things that are obviously in the mode of our past can teach us about our present, as legal historians can kind of frame their work, it is more incumbent upon us to provide policy lessons or doctrinal lessons for the legal academy. And I think that probably anthropologists struggle in particular with this obligation, but it is something that a lot of qualitative interdisciplinary scholars find difficult to do. We still have about a minute and a half if anyone else wants to jump in before we move on.
I'd like to follow up on the observation that you made, Elise. I thought that was so fascinating about the difficulty, the tension, I can't remember the word that you used, in moving from, the heart, maybe the methodological heart of an article to that last section where you need to do something normative or prescriptive. And I was hoping you could just describe your ideal. What would be the ideal way to address that, really that norm in legal scholarship, especially given the primary means of publication and law review, student edited law reviews, that you have to come up with some sort of prescription or something, leaning towards a prescription at the end. How would you address that if you could? What would you do?
My hope is this panel is going to address that for me, because thus far, truly, as I'm turning my dissertation chapters into articles, most often I write and I think, actually, I'm going to send that to a peer-reviewed outlet, because I cannot figure out how to get to that normative prescriptive part. In part because, and now I actually think part of it is at the front end. You have to think about designing your study, knowing that you're going to have to get there. I wasn't super savvy about that when I was doing this for my dissertation. My next project, I'm immediately thinking about what can this tell us in the part 5. That's a much more long-term thinking. The other part is, I guess, there's 2 parts to it. I think answering that. One is getting out this mindset that you get into with social science, which is thinking about the conversation your work is having with a particular theory, which is often the conclusion of my articles, which is what is this telling us about some theoretical insight that we've heard before. And instead thinking about, so what does knowing this, if I manage to explain something about the world, if I manage to explain something about humans interacting with law, what does this do to make things better? Or what can we do in response to this, knowing that we've recognized this problem to make things work better within the legal system or
I'm going to jump in quickly, Elise. Do you want to wrap up so that we can move on to John?
Yes. So that's a quick answer to that, but I'm hoping that we'll continue to find answers to this, and looking forward to hearing what the rest of the panelists have to say.
Great. John, your 5 minutes are on.
Okay. As I have thought about qualitative scholarship in the legal world in the run-up to this panel, I keep thinking there's a lot of good news, and there's still a fair amount of, I don't know if it's bad news, but less good news. On the good side, there's lots of people doing this. You're all here. Allegedly, there are 78 people out there listening to us. So there's a lot that's going on. And I really like Beth's point about clinical scholarship. I think qualitative scholarship in law has grown in tandem with both the numerical growth and the enhanced status of clinical teachers and scholars. I don't think that's a spurious correlation. There's some cause and effect going on there, and that's all to the good. I think there are an increasing number of examples where qualitative scholarship has penetrated the mainstream legal consciousness. I think, for example, of Beth's work on legal education. People everywhere have been moved to rethink what we're doing to these students as a result of Beth's qualitative work. Just one other example among many I could cite is Mitt Regan's work on legal ethics, focusing on narrative and interviews, excellent qualitative work, and that's formulated rethinking, I think, within the traditional legal ethics community, a different way of understanding what's going on. Tenure and promotion, that's the ultimate bottom line. I guess it was about a year and a half ago, I was an outside reviewer for a tenure case at a good law school that was based entirely on ethnographic scholarship. It was spectacular work, and the candidate went through very smoothly. I don't know whether that was an outlier in what I would think of as a good direction, or whether that's increasingly the norm. I hope so. If I think about areas where there's less progress as I define it, I think a lot of it is due to the continuing radioactive afterglow of the law and economics movement. That seemed to indoctrinate a whole generation of interdisciplinary people with some very fixed ideas. A fixed idea about what empirical means, a crime against etymology, that empirical means based on quantitative analysis. People in the Enlightenment would be surprised to hear that. So there's that. And when I present my own work, even to my own faculty, I continue to bang my head against the same walls. Well, this isn't evidence. Where's your statistical analysis? What I view as very primitive kinds of questions. This isn't proof of anything. How can you generalize? And I think it derives from this law and economics kind of perspective that the law's got some questions of interest, and you people with these other generally worthless degrees, go out and perform studies to respond to questions that the law poses. Again, back to Beth's work, I think what we can do as qualitative scholars, and I know we can as anthropologists and linguists, is to say, we really don't care that much about your questions. We want to look at what's going on from square one, from first principles, and raise some new questions. Did you ever think about this? And did you ever think about that? And that's a huge accomplishment to be able to do that. Nothing drives me crazier than someone saying, oh, this is pilot research. Hell, it's pilot research. Anyway, so I think we're still up against that. These norms about what empirical research means and about what the role of interdisciplinary scholarship is, in the sense that it's to answer questions that the law has already posed, generally with quantitative research. And I think we've just got to be persistent, raising first principles kinds of questions with our own research. So I will quit there.
Great. Thank you so much. I am going to jump in with moderator's privilege to say I really appreciate your point about what empirical means. I mean, during the course of this conference, I've encountered people using the word empirical to mean quantitative exclusively, and clearly so. And I think that whenever this happens, I have a unfortunately knee-jerk reaction where I want to stand up and shout qualitative research is empirical too. But I think that there, as much as that needs to be done, I'd like to think of a more proactive and maybe less defensive way of doing this, rather than simply always responding to what I perceive as generalized misuse of the word empirical. But I appreciate your point. Anyone else want to jump in?
Yeah, I would just jump in. I appreciate the point you raised, John, about reformulating, rethinking whether the questions that, right, the quote unquote law is posing are the proper questions. That, to my mind, has been one of the most productive ways to frame ethnographic research, which is to say, this, is the mode of research that enables us to understand what questions need to be asked. So in the work I do on anti-discrimination law as it pertains to the jury process, we can certainly take for granted, and there are many cyclical footnotes that bring us back to how the law understands discrimination and the impacts of anti-discrimination, right, doctrine and law. But once you're actually in courtrooms, observing how juries are being picked and speaking with lawyers about how they understand discrimination, you need a whole new set of different language to understand qualitatively what is going on. And I can't imagine anything more fundamentally, right, foundationally empirical than that. So, but it is a continuing challenge. And, this is the kind of translation work, as Beth has framed it, that I think is, part of a continuing project for all of us.
Anyone else?
I had a question. I think about, with both John and Beth, and I mean this with utmost admiration, is I often have to check myself. Where are you? Are you in a law school? Are you in an anthropology department? Because you manage so well to, I think, speak to both groups, and both groups are happy to claim you as their own. And I'm curious if you can talk a little bit about the work that you put into that in terms of preserving both identities without necessarily being pulled. Because even this early on, I feel like I'm having to choose sides, or either in an individual kind of presentation or publication, or just in terms of shaping my own professional identity and who my community is going to be. And so I'm curious if you had some insight or some thoughts about how we can navigate that.
Beth?
I want to hear you talk first, John.
Okay. I have always benefited from underthinking things. In hindsight, that's been a virtue. I underthink things. I never really analyzed it. I mean, I was always have always been situated with anthropologists and other social scientists, literally in terms of the work I do. Mac O'Barr, my longtime, now retired colleague, and also with lawyers. And depending where I am, physically and metaphorically at a given moment, I try to be totally in that world. So I've had my teaching is probably 75% conventional, civil procedure, among other things, patent law. But in my scholarship, I just tried to be both. I'm sure I fall well short on each side because I'm trying to do two things at once. But I've always tried to do both and to be fully in whichever thing I'm doing at a given moment, and not really worried about who am I.
That's surprisingly really simple, but very good advice. Thank you, John. Beth, we've got like 30 seconds before we move on. Can you say
Oh
something?
gosh, well, and I actually, maybe later we can get John to tell about how he taught a class that was really right at the edge of qualitative data collection and getting the students ready for practice. And I think that's actually, and Riaz Tijani's written about that. He's an anthropologist, about how actually our skills translate really well for teaching when we can figure out a way to do it, because students want to know what they're going to do in practice. And we can actually bridge that using empirical work that is also attentive to the more abstract level that you teach in doctrinal classes. So
Great. Let's move on with Rashmi.
Great, thank you. And I'm thinking that I'd like to spend my 5 minutes focusing on a particular aspect of this question that's driven by my current position as an Associate Dean for Research, as I mentioned. And I think I'm going to try to end not with any provocation, but rather a sincere expression of a few wishes. So this is my perspective. This is my particular perspective for the focus of my few minutes. And I think the couple of things that I'd really like to focus on, again, from the perspective of an Associate Dean for Research, is just first of all, the question of how, if at all, just the question of representing the availability of qualitative scholarship might be relevant in conversations with individual faculty members when trying to advance the enterprise of research in a particular institution. And then the other quick pause that I wanted to make was on the issue of conference planning, again from the perspective of a research dean. So on the question of talking with individual faculty about their research, their own research trajectories and wishes, I will say that my own experience trying to do qualitative research, and then also actually my foray as an institutional sort of advocate within my law school in the research enterprise, my experience with just the conversation over the last several years about the crisis in legal scholarship has really made me think differently about how to advise very junior faculty members at my institution, but also those who are sort of mid-level and even more senior, but thinking about new things to reach for and how really to define their own scholarly endeavors. And the couple of things that I feel that I regularly try to foreground now and make less invisible are, first of all, just the question of methodology, right? So many folks assume that what we do is, when we write, is again to write in such a way as to achieve some sort of prescription using, a relatively small number of formulas to get there. But they don't define their work, their scholarly work, as any particular particular kind of methodology. And it's only, I think, recently when Robin West started writing about normative legal scholarship that we even started to call our work that, right? I think many of us just didn't talk about methodology at all as legal scholars prior to that point. So one thing I find myself regularly asking my colleagues now when I talk to them about their research is, well, what is your methodology? And it is one way to put on the table just the question of whether one's methodology is really purposefully normative, or whether there might be alternative ways to get to the points that they're trying to make by the end of that particular piece that could involve a different kind of methodology. And it also, of course, gives one an opportunity, a sort of natural opportunity to talk about what empirical might mean other than quantitative. So that's something that I found to be just a useful part of regular conversations. And then the other piece of that conversation that I find happening regularly is just the piece where we redefine or just think further about terms like case study, which very often I think lawyers use in talking about extended examples in our law review articles or legal scholar issues without necessarily thinking about how case studies might be defined in other disciplines. So these are two examples of conversations that regularly come up in my work that allow me to think, I think, more actively with my colleagues about the question of methodology. And then the second and really very related opportunity, I think, that I have in thinking with colleagues in a one-on-one conversation about recentering qualitative empirical scholarship is the question of audience. So, more and more as we're sort of engaging in this discussion about the crisis in legal scholarship, we talk about the fact that our audience no longer seems to be primarily comprised of judges. Judges don't actually care as much as they seem to have before about what legal scholars think and write about. And so who is our audience now? And again, that leads relatively regularly, in my experience, to conversations about whether different methodologies are appropriate in order to reach the different audiences that we're trying to reach. Deepa, I have no idea where I am in time, but I'm going to...
I think let's open it up for some discussion because you've raised a lot of great points.
Well, all I'll say in 10 seconds is I think the same conversations come up regularly in conference planning, and that it's just another opportunity to think very actively about the relevance of methodological diversity in planning a group of speakers. Sorry, I'm done.
That's very true. Would anyone like to jump in? John, go ahead.
Yeah, I want to ask you a practical question. Put on your Dean for Research hat.
Yep.
I came up for tenure in 1987, and our dean, who was very interested in, sympathetic toward my anthropology side, said, you know what, write a couple of copyright articles too, just to shut up those people. And I'm not sure I wouldn't give the same advice to an interdisciplinary junior faculty member today.
I get the same advice. For what it's worth.
You get that advice? Have you gotten that advice, Deepa? Yeah. Would you give that same advice, Dean Rashmi?
Yeah, if I had not forgotten to look at the starting time for my commentary such that I ran out of time, that's exactly where I would have gone next. I mean, it absolutely has to do with my wishes. I would give the same advice, and here's why. Because I would do it very reluctantly. It's because when we think about choosing outside reviewers, we still, I think, define field, the question of who the list of outside reviewers is going to be by field rather than by methodology. So if I had had time to present several wishes, my first wish would have been, could we find a way to help folks in my position and chairs of tenure and promotions committees to define lists of outside, to build lists of outside reviewers, partially by methodology. And throwing the question back to you, John and Beth, would you be willing to be an outside reviewer for someone who might not be in your field, right, defined as constitutional law or criminal law or whatever else, but who was richly engaging in a qualitative, empirical, methodological set of scholarly pursuits?
Beth, John, either of you want to respond?
I'm going to talk more about this, but that is happening with me right now. And to the extent I can, I do that. And the reason is that I'm listed as someone who does new legal realism. And I want to talk about that as an organizing tool, that I am now getting asked to review tenure files for people who do qualitative research in different kinds of fields. I think it helps that I'm an anthropologist, so if it's so-called international research, they might have asked me anyway, but I actually am getting contacted because of that. And so I do think there are ways to signal, and then you really do have to get beyond me and John and sort of a small group of older generation people, and that's another thing I'd like to talk about. But I'm so glad you raised that question, because I think that's almost step one. Of course, people in law and economics had that. That's one of the things they tried to do, and they succeeded. If someone was coming up for tenure, you knew a group of people you could send their tenure file who would be sympathetic to and understand the method they were using. So.
We've got about a minute and a half before we need to move on. Anyone else want to jump in?
I second what Beth said.
Oh, geez. I wish we could get my kids to listen to this. But anyway. So I also was really struck by this issue of audience, which I think everyone needs to think about. Anthropologists are not that great at this either. And so I would love to hear a little bit more about how to think about reaching beyond the typical imagined audience of law review articles for today's legal scholars. Because I was also given that advice. I did that, and I was at Madison, and Madison was at the time very invested in Law and Society scholarship. Law and Society is also a really great networking place for empirical researchers of all varieties, who do both legal scholarship and want to be in disciplines. But I worked on family law. That was one of my bread and butter courses, and I published doctrinal work on that going up for tenure. So, but I'd love to hear more about how you could break out of that kind of audience as well.
I'm going to jump in with a quick comment before we move on. I've realized that in the pieces I've written that are my favorites, whether or not they're anyone else's favorites, I've always inadvertently written for a particular person with certain skill sets and backgrounds, and not necessarily someone who is by subject matter or even methodology closest to myself, as myself is represented in that particular piece, but just happens to be the person I'm mentally having a conversation with. And I think, what does this person need to know in order to understand what I'm saying? What would this person find interesting or relevant or whatever? Sometimes that's happened when articles, now less recently, but articles have grown out of projects or class papers or things like that. But now sometimes it grows out of conversations at conferences. And I think that has helped me to not get too hemmed in by what would a doctrinal legal scholar think, or what would a anthropologist think, or anything else like that. But I'm breaching my own rules, so I'm going to pause and hand it over to Beth for 5 minutes.
Oh, okay. So I actually do want to use this time to talk about new legal realism, which I've been told by my younger colleagues I'm too shy about talking about because it has felt too close to self-promotion, because I've done a lot of work in the area, but I'm now no longer doing it. There's a group of young people coming in, and there's always been a large group of people working on this. And I think it's useful to think about, really use our social science skills to analyze the situation, analyze the institution, and ask what does help when people are trying to get a particular approach seen in the legal academy. So New Legal Realism was started by a group of largely qualitative scholars working in law schools around the turn of the millennium. And by the late 1990s, although we knew law and econ was there to stay, it was clear there was going to be a search for a new thing. There always is, even in other fields as well. And so I want to give a shout out to my late colleague, Jane Larson, who at the time saw this coming around the corner and was really worried that, given what John said, given the mindset already in place, that, and also a very common one in our culture, that this new thing would be exclusively quantitative. And so, along with a number of other law and society scholars, frankly, at Wisconsin and elsewhere, David Wilkins from Harvard, Martha Feynman, now at Emory, were part of that group. We met and had an initial conference. And the American Bar Foundation was part of that as well. We held events at the AALS, like when there was already a training for quantitative methods, we proposed doing, okay, well, how about a workshop for qualitative methods? Because it's actually a method, and it's actually easy to mess it up if you don't have some training. So we tried to work and are still working in the interstices. We're working on issues around rankings as well right now. And indeed, as we all know now, the Legal Academy did turn to behavioral law and economics, as well as to a form of empirical legal studies. Ironically, that came out of Law and Society as well. And I think that's been helpful in bridging some of the problems that started to emerge. But in its initial stages, it did indeed try to redefine empirical as excluding qualitative research quite explicitly. And then there were other attempts to start a new legal realism that would be exclusively quantitative. But by that time, this group was underway and was pushing back. And I'm not saying that they alone had the impact. A lot of other people were pushing back. But I think pushing against limiting definitions of empirical and against attempts to claim legal realism for a smaller tent, this group tried to develop a big tent version of new legal realism that would speak to qualitative as well as quantitative. And I can talk at some point about disputes over the legal realist legacy that Brian Leiter tried to have, that folks stepped up to in different ways. But there was an opening conference in Madison in 2004, resulting in paired publications in a peer-reviewed journal and a law review, which was one of the explicit things we tried to do. And the 10-year anniversary at Irvine, which is, I think, where a lot of the NLR energy is moving these days. And I think we've had an East Coast and a Midwest version of legal realism, and we may be about to see a West Coast version, although always reaching to all of us. And I think that's the problem in a way, is how to do that, and something that I'd love to get people here to think about as well. And then you see, because we were doing that when the European conference was held in Copenhagen, they invited some of us, and then we got a chance to be in a conversation that now goes around the world, and that we have folks, NLR people in China and India, Israel, South Africa, and all of our volumes are trying to be explicitly inclusive of scholars from the global South and elsewhere. And so I can go on at length about this. It's like herding cats to work with all of us. I mean, all of us as scholars are not all that interested in joining something or doing something because we're all deeply enmeshed in our own scholarship. But over time, I think the group, as it's growing, there's going to be a research handbook of modern legal realism coming out in the spring that Shaheen Talash took the lead on, and again, mingles law professors and social scientists, research from many disciplines, always showing how qualitative work is crucial in arenas from policing to immigration to law school reform to access to justice. So I think these projects have started to form a network of people specifically located in law schools who want to do qualitative research, not to the exclusion of quantitative research, but in combination. And I think it might be that kind of effort that could help just even strategically. And I think we tend to think of strategy as something kind of low and something you don't want to dirty your hands with. But every major effort at a school of thought in law has had strategy. And I hope that this group will think of it as well.
Yeah, no, I think the importance of institution building and kind of creating a collective memory and repository of resources is really vital and something that NLR has done a great job of doing. I'm going to turn it over now for 5 minutes if anyone else on the panel would like to jump in.
I was curious if you could say more about where you think NLR is going to bring us that Law and Society hasn't quite managed to do. Because Law and Society tried to do that. That was the first, I think, goal of Law and Society, which was let's bridge law with other kinds of scholarship. And it's a complicated history. It obviously is not 100% successful. And so I'm curious if NLR is responding to particular gaps that it sees or missteps, or if it's just saying that there's just another way of doing this, and if that's explicit in the strategy.
Well, it is, in a way. It was a response to that failure of Law and Society. And I have to say, the first meeting that was held at Law and Society, because we meet all over, including AALS and Law and Society, we got a room full of people, but they weren't that wild about helping law professors do things because they were in their own disciplines, marginalized, making lots less money, having lots less power, and not that interested in the problems of law professors. So we got a room full of, fine, go and do it, but we're not that interested. Now, in the 2-volume set on NLR that came out from Cambridge a couple of years back, Michael McCann wrote a lovely introduction saying, here's why Law and Society people ought to care about this, because, we're not reaching law schools, and there's reasons why, as a group, we shouldn't be that concerned about it, but we now have a substantial membership of younger scholars who are trying to navigate the waters that have been described in this panel, which are troubled. And there's another reason why qualitative research doesn't do that well in the corridors of power. And it's precisely what people have been saying, because to really use it, you have to use it to unsettle frames and to ask questions that people don't want to ask. And that's tough uphill work. And we're not going to have massive funding from the Olin Foundation for reasons that, like Ann Southworth and other Law and Society scholars have spelled out. So Jane Larson's original question to us was, okay, you don't have the money, but you have the position. Why are you not trying to use it? Why are you not trying to use the skills that you have and the power that you have? It's minor compared to, Cass Sunstein or somebody, but it's great compared to a lot of other people. Why are you not using it to try to see this point of view held up and kept in view? And because it's important, it's empirically important. So,
Can I follow up on one of your points, Beth?
Yeah.
You talked about why would anthropologists or sociologists want to help lawyers? That's a really serious problem, and that's one that hasn't gone away. I think any of us on a law faculty probably makes about twice as much as an anthropologist of equal quality, maybe in the same university.
Right.
That's a tough sell for law professors to say, answer these questions for us, if you don't mind. And something that is exacerbating that now is so much qualitative research light is being done by law professors that people in those disciplines, whom people in those disciplines perceive as unqualified. There's light ethnography, there's light linguistics, all the talk about culture. The current focus on race, I think, is becoming an example of this. I mean, anthropologists have been talking about what race is and what it isn't for years and years and years, and thinking about it in very deep ways. And all of a sudden, the legal academy latches onto this, and anthropologists say, why aren't they asking us what we think? Why are they bringing in these ambulance chaser consultants instead of going across campus to the anthropology department. So
And there's
again, tough sell for law to get into these disciplines and collaborate with them.
Do I have time, Deepa, for an answer? So there's a really good answer to that, by the way, and it's one of the reasons I accepted to go teach Anthro this spring at Chicago. Because Anthro isn't that good at this, right? So you now have Jonathan Rosa, who came out and called linguistic anthropology and anthropologists on how we've naturalized actually the category of whiteness. And so one of the things I'm just so struck by, and I have to say to you that as someone who's worked on this forever, as I started to read across, I've been reading critical race theory for a long time, but as I started to really put this together, I kept seeing places where Anthro needs to actually listen to scholars of color who are telling us that maybe some of our methods need updating, right? And so it's actually a really fermenting, exciting space, although challenging, of course, for people across these disciplines. But in fact, legal scholars of color have led the way in conceptualizing this, I think, in ways that anthropologists have taken in without really getting it, that they're following in this case. And so I'd love to shake I'm echoing Jonathan Rosa in a recent talk where he said, I'd like to shake this part of the academy up, and it has a lot to learn from law. So, I think it's a very valuable conversation for us all to have together.
Great. Now let's move on to Anna for 5 minutes, and then we'll have our last little discussion session and hopefully have a few minutes for Q&A. Anna?
Yeah, thank you, Deepa. So I just want to take one of my minutes or part of one to also just respond to Beth in saying that a truly extraordinary contribution of New Legal Realism loops back to our discussion of audience. I think for so many anthropologists, legal anthropologists like myself, it was reading New Legal Realist scholarship that made thinkable and intelligible a way to communicate with law professors and, within the context of legal academia, without which I at least can say firsthand, it would have been extraordinarily disorienting and unimaginable. So it has also contributed that. So I want to respond in the next few minutes to the central question, an important question that Deep has made central to this panel. So, right, what does it mean to rigorously pursue qualitative interdisciplinary legal scholarship? Relatedly, right, something I think we have to grapple with here, and a provocation, if you will, is how, right, legal academic understandings of qualitative interdisciplinary rigor might differ from qualitative interdisciplinary scholars' understanding of rigor. So where do these ideas of rigor overlap? Where do they diverge? And how importantly can law schools address these divergences to encourage qualitative interdisciplinary scholarship? So I'll just focus for a few minutes on how, as a legal scholar and cultural anthropologist, I've come to understand what rigor means in this context, and how law schools, and I use SMU as a model here, can embrace and facilitate this kind of work, which I think has to be done very deliberately and thoughtfully. So first, my own experience and understanding, rigorous qualitative legal research, often does involve interviewing, observing human subjects, and it's marked by the time that it can take to plan and design these sorts of studies. So this can involve time spent, applying for external funding, developing, your institutional review board protocol, time spent considering the ethical implications of different types of human subject research. This has been particularly brought into relief in my own work during this pandemic and what that might entail. And it also might involve time spent soliciting peer feedback, wholly apart from blinded peer review processes as part of publication. So ways that law school can help facilitate and promote this kind of research, one that I've really appreciated in SMU, is by very explicitly trying to encourage interdisciplinary partnerships, not just across law faculty at a particular institution, but across liberal arts campuses more broadly. So this can include, right, resources permitting, encouraging direct interactions with social science researchers. So right, some schools have the benefit, as SMU does, of having a, criminal justice, the Decent Criminal Justice Reform Center, which operates a lot like Princeton's program in law and public affairs, and putting practitioners and scholars in direct conversation with one another, creating opportunities for collaboration. But I think this pandemic has shown us very clearly this does not have to be a very resource-intensive sort of collaborative process. It is possible to create workshops, interaction, to encourage informal affiliations, courtesy appointments by law faculty and liberal arts departments. So this is something I've seen at least be incredibly productive. And in thinking also about different conceptions of scholarly rigor, there are also, as we've mentioned here, different norms of publication, which can be distinct, right, but certainly complementary to legal scholarship norms and law reviews. So I've been very heartened to see, I don't know if others have felt this to be a trend, but law reviews seem to be taking a much more active interest in publishing what we consider, right, empirical legal scholarship, qualitative legal research, both in implementing, right, formal blinded peer review processes in some cases, and I'm thinking in particular of Northwestern Law Review here, devoting an entire issue to the publication of empirical research, but making a very concerted effort to include qualitative research, right, among its pieces. So I think, right, where qualitative interdisciplinary research diverges from legal scholarship, is, in the creation of monographs, writing books. This is difficult. I think it's a challenge for law schools, as part of a panel I participated in earlier. But here again, I think, trying to, make a concerted effort to create opportunities for faculty working on books as opposed to articles, to, workshop, draft, manuscripts, chapters with those outside of an institution is a very important, but has to be a concerted effort on the part of deans and colleagues who may not recognize this as the traditional mode of legal scholarship. It may not in the future count towards rankings as things play out, but also go a very long way in aligning these different ideas of rigor. And I would just
Anna? Oh, sorry, go ahead.
and
why don't you wrap up quickly?
Stop there. I'll stop there, and I'm interested to hear what others have to say. Thank you.
So I'm actually going to throw it back to you and to the other panelists with a question that's kind of based off of something you said here and in your earlier panel about publication norms and the difficulty of kind of balancing, not speaking to two audiences in the sense of intellectual traditions or methodological obligations, but in the sense just of format, right? Like peer review article versus law review article versus monograph, or all of those kinds of things. And one of your earlier co-panelists said that, yes, this is something, doing a book as a junior law scholar is something that a lot of people are advised against doing because it detracts from your ability to publish law review articles, which after all are the coin of the realm. But you can walk and chew gum at the same time, which in fairness has largely been my thinking about things as well. But I think that I sense flippancy in my own reaction to that potential problem. And I'd like to hear maybe your thoughts on kind of disaggregating work across different types of publications. And then maybe also from some of the other panelists, but Elise, in terms of what you're thinking of doing, you said that you were breaking up your dissertation into different articles, and maybe from John and Beth about what you've seen junior scholars do over the years. And Rashmi, you're in an administrative capacity, kind of what you mentioned earlier, you would reluctantly tell junior scholars to also publish law review articles, but maybe let's flip it and think a little bit about the other forms of scholarship. So Anna, quickly, and then we'll kind of open it up to everyone else.
Yeah, I mean, to the walking and chewing gum analogy, I wish it was as simple as that. I would love to finds the minutes and hours, in a day to carve out a space for these projects. But in practice and reality, that is, it's very difficult. I don't know what to make, for example, of very explicit advice I've been given to put the book out of my mind completely. It is irrelevant. Focus on articles. There will be colleagues I have in my law school for whom a book is utterly unintelligible and might be a nice extra, but without the basis of law review articles is utterly meaningless and should therefore be set aside. So I think I'd be very interested to hear others' experience with this. I think that is one of the most challenging dimensions of entering a different sort of academic scholarly space, insofar as one thinks of the culmination of doctoral research in anthropology as a monograph, and that is simply not a law school norm. And so what does one do? Do you spend the midnight hours working on your book, or do you take seriously the possibility that this is something that could have repercussions? And I think so much of that depends on the sort of the mentorship, the models available to you. You happen to have an institution setting a precedent for this sort of project, because as many of us, it is an enormous undertaking. I mean, there's no end to the process of creating a book, and so whether to undertake that or not as a junior faculty member at a law school, I think is truly an open question.
Anyone else?
For what it's worth, Anna, I've received similar advice, and even more than that, I've received advice. Maybe wait on your next ethnographic project until tenure. So this idea, it's not even the writing, but all the work that goes into it, and that's. I think your framing as rigor is exactly right on. It's different calibrations of rigor, and also what we count as evidence of that rigor, because all of these things that go into the research part are extraordinarily trying and rigorous, but they don't have tangible products that you can measure, and so it's hard for you to put that out there and say, I've accomplished all of this stuff, because there's not much to show for it other than, believe me, I was doing these 3 years of fieldwork. So just wanted to echo what you said. And I think, I think that the publishing articles, and it's publishing articles and making sure that you're publishing articles that are legible in law school. So taking your dissertation, not just don't make it a book, but make sure that you're also then writing articles that have nothing to do with your dissertation, because that doesn't exactly follow through in the identity of a doctrinal scholar.
Let me add one thing to that. The norms of faculty scholarship and the norms of what counts for tenure weren't handed down by God on Mount Sinai. They are a collection of choices made in real time over the years by tenure and promotion committees, and then by tenured faculties. And they can change very quickly if people choose to change them. I've chaired our committee probably 15 times. And about 5 years ago, I was the initial drafter of our new tenure standards, which hadn't been touched since like 1970. And I put all this stuff in there about what kinds of scholarship counts and should count, and empirical, qualitative, quantitative, and probably because nobody was paying attention, this went through, and this is the standard. So these things can be changed if tenured faculty and committees want to change them, want to expand the concept. I think that's part of it. Another part of it is a very high fiduciary duty from people who are administering tenure to be forthright and honest with the junior faculty about what's going to happen and what is going to count. But these things can change if there's will to change them. They're just written standards, and they're just cases of application.
I'm going to jump in quickly because we have just a little over 5 minutes, and we have a couple questions in the chat that I wanted to just sort of throw out to everyone. The first is, what is the difference between qualitative research versus other forms of more traditional legal research? And the second is, what are the hallmarks or qualities of good qualitative empirical research? Those are doozies. I'm going to let one of you handle them. Would anyone like to take a stab?
Okay, I'm old and stupid, so I used to be young and stupid. Empirical qualitative scholarship versus traditional legal scholarship. I think it depends upon the evidence, the methods of analysis of the evidence, and how you draw conclusions from the evidence. Traditional legal scholarship looks at statutes, cases, things like that, looks at legal authorities, and the writer asks, what do I think about that? What can I do in terms of coming up with a better way? So it's very intellectual, it's very intense, but the evidence is fairly contained, and it goes on in the head of the analyst. Qualitative empirical legal scholarship may look at those kinds of evidence as relevant. It can also look at anything else, looks at the state of the world. And I think it's incumbent on the analyst to go outside your head and say, this isn't better or different because I think it is, but I can connect my thinking to a piece of real evidence in the real world. I may not be able to count it up, but I can say, this is really happening. Real people are actually expressing this thought, and I will connect that to my legal analysis.
And one thing I would say is within the legal academy, the boundaries are blurring in different ways. And it's always interesting to watch how and where that happens. To me, one of the genre-specific differences is that often legal writing and legal scholarship is marshaled toward a goal that you've decided ahead of time. So you're trying to make an argument. You throw out anything that doesn't fit, and you keep this, or you dismiss it, and you keep the stuff that fits the idea you started with. And I think really good qualitative research, like really good quantitative research, allows what you find to guide what you say from where you go. And don't just look at you also choose what you look at, right? So you don't just go look in places, and you don't fail to listen to people who might challenge the ideas you came in with.
I think that's a great point of distinction. I remember discussing a potential paper project with a senior colleague with whom I have great conversations and receive wonderful advice. And I said, I'm not really sure where this is going to end up because I don't know what I'm going to find. And this colleague was like, I never begin a project that way. I mean, that sounds, I don't remember if the word was terrible or terrifying, but it was definitely one or the other. And I think that is it. There's a kind of state of suspended knowledge and belief that you exist in for a long time when you're engaging in qualitatively influenced or informed research, whether or not that then incorporates traditional legal sources and forms of analysis as well, on kind of maybe on the back end, maybe not so much, but is significantly rooted in qualitative empirical research. We've got a couple more minutes. Anyone want to throw in either some more thoughts on these questions or anything else that has come up previously in the discussion? It can be a bit of a non sequitur.
I'm curious if people have any kind of concrete thoughts about ways in which we can take this discussion and use it to move forward the presentation of qualitative scholarship and qualitative research, either in the way in which we frame our drafts or in the way in which we are presenting. Are there concrete things that I tend to do in terms of this long introductory overview, which gives kind of trying to answer the questions that were just posed in a way of kind of justifying what I'm doing. But I'm wondering, are there other techniques? Is that something I should be avoiding? Is that something that's in a sense too defensive from the outset? I'd be interested in thinking about actual strategies for making this more apparent to people who are not just within this particular panel or within this particular session, the people who will be reading our stuff, evaluating our stuff, or listening to us elsewhere.
That's great. Go ahead.
Go ahead, Beth.
I mean, just really quickly, Tom Tyler, who's a big deal in quantitative research, always used to say when he was at the ABF that he never started a quantitative study without reading the ethnographies. And he would still tell you that you can't do this kind of work in isolation. Every quantitative person I've ever heard gets to the end of their presentation and then has to figure out, what does this mean, right? What do these numbers mean? And as often as not, they're saying, well, we need more quantitative work to find out what it means. And so I would really love to see people start situating all the things they're finding, whether from legal analysis or quantitative analysis, in terms of what does it mean? And what does it mean to a community? What does it mean to the people who are the subjects of law or the people who are administering law? And that's a qualitative question. So not very helpful, but just a thought.
No, I think that absolutely is helpful. The interpretive addition and process is one of the things that qualitative empirical work brings, both to other forms of research like itself and to the legal academy more generally, right? So I think that's actually a great note to end on, which unfortunately we now have to do. Thank you all so much for taking the time to have this conversation. I really enjoyed it and learned from it, and I look forward to continuing the conversation with all of you.